the first to know. Nsem-Pii TV.
Justice Torkonoo asanka no ho biom. Ne question and an assembisa etiawa. Se moyimi as Chief Justice a esimi kwan se metima ye adwuma as Judge of the Supreme Court ana. Obi nso betima ka se obaye Member of Parliament ni you as Minister na kwan bi so ye fire as Minister. Say why boni bi etia President of the Republic of Ghana and as one ministerial Germany year uluzu position as Member of Parliament and I name say ambassador because ukoye Minister of Energy na President kasa o reshuffle and as obi before ba shakwa and then see ukwan say o Member of Parliament ejuma no automatically ye as minister nti ubejai say ejuma na ye sa so na Justice leadership get to Torkonoo eka say yini as Chief Justice and only see ni kwan say ejuma waye over the years ababe Judge of the Supreme Court and also so omeyina na constitution nso so e wo kwan a omo faso edi Chief Justice and omo kwan omo de faso e Judge of the Supreme Court osisa kwan na because e kwan na ye de faso e these two different functions na enye the same intino so mo person musan gino as a Supreme Court judge monsan fa sa kwan no so but as far as mon fa sa kwan no so there still now or recognizing no ho as a Judge of the Supreme Court yenko tie Dennis Miracles Aboagye legal argument to raise here was Samson Lardy news file.
You must be a person of high moral character and proving integrity. High moral character and proving integrity. And to lose that job, you must have been found to have conducted yourself, stated misbehavior, or incompetence, or infirmity of body or mind, and so on and so forth.
So I think that when it comes to issues like this, nobody should assume any role or responsibility that the law doesn't give you. I believe that we need to be a bit more fair to the Chief Justice. At this point, after whatever the government wanted to do, they've done, I think it's time for us to calm down and begin to give her some hearing. I have always had a problem with the basis for a removal and all the things they went through. I mean, first of all, I think that there is no audit report from any auditor general indicating the primary, allegation they used against her. And I don't think our laws allow any other committee or body to determine these things other than the auditor general. I am very sure that when this government eventually leaves office and this woman gets an opportunity to go through this process again, we'll see a lot of gaps. But it's okay. For now,
it's not only the financial impropriety
most of them,
that was used.
Most of them. I mean, for now,
according to the outcome. And the letter that communicated her removal.
I agree.
She was also found.
As it stands now, nobody has even seen the report. Okay. Even she herself has not received a copy of the report from the president. The only thing she's received is a letter from the secretary indicating that she's been removed.
That's precedent.
I'm just saying that as of now, she hasn't received it. So we don't even know. We don't even know in proper terms the basis for a removal other than what the president has stated. That's what I'm saying. When this government eventually leaves in 2029, we will know the details. That notwithstanding, I just want to ask. I know if I'm a judge, I'm supposed to live above reproach. So I am caught for stealing. And I'm dealt with according to stealing, which is misbehavior. The law doesn't say that automatically I cease to be a judge. The law says that I must be taken through a certain process. And then I'll be removed as a judge. Is that the case? Then if that is the case, there's a process to remove the Chief Justice, which you've gone through it with me. There's a process to remove a judge of the Supreme Court. It is only fair that and proper that you take the basis and whatever ruling, whatever evidence here, and take it through the process of removing a Supreme Court judge. And that is what I think the lady is looking for. Basically, at this point, what we are doing is that we are saying that because we found you guilty on one thing, automatically you won't qualify for this. But here we are. And we are all clear in our minds that the person is saying, I wasn't even given a fair trial through this committee. So if she goes through the process of removal of a Supreme Court judge, she may adduce further evidence to, clear herself for certain things that have been made against her. But to say that because the processes of a removal of a Chief Justice have been seen through, and for that reason she has been removed, automatically she ceases to be a judge is to say that if a judge is found guilty on a crime, automatically that judge ceases to be a judge. When the Constitution or the law itself has given a process that you should take a judge through before they are removed.
Have you tried to look at what the difference is about the procedure for removing a Superior Court judge and the procedure for removing a Chief Justice?
The simplest, one of the basic differences I've realized is that if you're going to remove a Supreme Court judge, the Chief Justice handles that, right?
What do you mean by handles that?
It goes to the Chief Justice. Now, if you look at the committee,
it goes to the President.
Yeah, of course, and the Chief Justice.
The petition will go to the President. The President will send it to the Chief Justice.
Yes.
Then the Chief Justice will determine whether there's a case to answer or not.
In this case, the committee, actually the membership of the committee, as to whether they have the jurisdiction to remove a judge of a Supreme Court, is another question. So the fact that the membership of that committee, of course, the membership of that committee, do they have proper jurisdiction to remove a judge of the Supreme Court?
Or the committee or the committee?
No. The committee. The committee.
That was set up.
That committee has jurisdiction over determining the fate of a Chief Justice. But do they have the jurisdiction over determining the fate of a Supreme Court judge? If they don't, then all you have to do is take whatever it is that they have done, which is now evidence of whatever crime the Chief Justice may have caused,
stated misbehavior,
and take her through the process of removing her as a Supreme Court judge and allow her to defend herself.
Okay,
that is the law.
So the Constitution says, I'm coming. The Constitution says, as a Supreme Court judge, or as a Superior Court judge, or as a judge, the only time you may be removed is that you have been found on these grounds, stated misbehavior, incompetence, or inability to perform the functions of your office arising from infirmity of body or mind. Are you saying that if, in this case, having been found guilty of stated misbehavior over financial impropriety, over attempt to appoint extra Supreme Court judges, etc., it can only remove you as a Chief Justice, but not as a Supreme Court judge, regardless that the verdict is that you have been found guilty of stated misbehavior?
That is why I said that. The 1462 is clear. It says that may only be removed by the procedure.
That's so 1461.
No, 2. I'm referring to 1462.
Okay.
Yes, I'm referring to 1462. May be removed
in accordance
by the procedure. And if you may, I can even read it. It's 146.
A justice of the Superior Court of Judicature or a chairman of a regional tribunal may
only be removed in accordance with the procedure specified in this article. The procedures are not the same. The procedures for removing the Chief Justice is not the same as the procedure for removing a judge of the Superior Court.
And the only difference, as you have indicated, first and foremost, is that...
Like, I think that is primary. That, for example, on this committee were 2 other Superior Court judges. When you are removing a Chief Justice, would these 2 other Superior Court judges be there? Would Domelevo be there?
Okay, so let's look at it. If you are removing a Superior Court judge, clause 4, where the Chief Justice decides that there is a prima facie case, he shall set up a committee comprising of 3 justices of the Supreme Court, or chairman of the regional tribunals, or both.
Which one are you reading, please?
Clause 4.
Okay.
1464.
Appointed by the Judicial Council, and 2 other persons who are not members of the Council of State, nor members of Parliament, nor lawyers, and who shall be appointed by the Chief Justice on the advice of the Council of State.
Yes.
So the first difference is that to remove a justice of the Superior Court, Chief Justice will make a prima facie case.
Yes.
And after that, the Chief Justice, together with the Judicial Council, will appoint the members who will form the panel. Then clause 6, where the petition is for the removal of the Chief Justice, the President shall, acting in consultation with the Council of State, appoint a committee consisting of 2 justices of the Supreme Court, one of whom shall be appointed chairman by the President, and 3 other persons who are not members of the Council of State, nor members of Parliament, nor lawyers. So the appointment of the committee to do the process is done by the president with the Council of State.
For Chief Justice
and
removal.
prima facie is also done by the president with the Council
Chief
of
Justice
State.
removal.
This is the difference.
For Chief Justice removal.
That's right.
But for the removal of a judge of the Supreme Court, a committee should be set up by the Chief Justice, not the president.
With the Judicial Council.
Yes, not the president.
Right.
Secondly, I made a fundamental point, and I think that's what we should all use our mind to. Let's say I'm a Supreme Court judge, and then I'm found to be beating my wife. And so my wife takes me to, Dofsu? And Dofsu takes me through all processes, and I'm found to be domestic violence. It doesn't automatically disarm me from being a judge of the Supreme Court.
That's correct.
But somebody can, based on that ruling, now petition the Chief Justice and say, this judge is a woman,
the president.
The president, and say, this judge is a woman beater. I don't know why you allow a woman beater to sit as a judge in this country. The president may now write to the Chief Justice. When the Chief Justice receives that petition, he will check whether me beating my wife, for whatever reason,
It's stated misbehavior.
is stated misbehavior, and it even affects or impairs my ability to be a judge. If he establishes that, then he will set up a committee for me to come and defend myself. Now, that committee's evidence against me will be that ruling against me being a woman beater.
That's right.
I have to prove to that committee that the fact that I beat my wife in the past doesn't mean that necessarily I cannot execute my function as a judge. You may disagree with this, but this is the law.
The
That is
standard
what
is
the law
that
is saying.
you are a
Because-
person of high moral character and proven
yes,
integrity.
but the law says that she may only. So there is only one procedure. You cannot imply any other procedure.
Okay.
So you may have a very solid ground for thinking that she cannot be a judge. But the law says that you cannot use that procedure of removing a Chief Justice, which is for the sex.
Okay.
To remove a judge, which is for
let me ask you
the
this, and I
cross-form.
move on to Roxanne. Hold on.
So what I think anybody should do, now is to simply, like they did for this one, get one of their guys again to write a petition against the woman.
Oh, please.
And take it to the president.
Okay.
Then the president will refer it to the Chief Justice. Then the Chief Justice say, Madam, you know you are no longer the Chief Justice. But people are saying you can no longer be a judge. According to the Constitution, 1464, come and defend yourself.
Please.
Then the Chief Justice will form a committee.
So the new Chief Justice.
Yes,
Okay.
because that is the only way you can remove a judge of the Supreme Court.
Yes.
You cannot use 6 to remove
So
4.
that at her time, there should be a petition sent to her to make a prima facie on herself.
No. The Chief Justice has now been removed. That is established. He's now been removed.
Okay.
That's why I'm saying that he's been removed
Samson,
as the
please,
Chief Justice.
Hold on. Don't worry. Allow him.
He's been removed
Yeah.
as a Chief Justice,
Yeah.
which was a function.
Okay.
Remember, it was a
The
function.
last question I'm going to ask you, let me put it to Theo Champong. Dr. Theo Champong.
I thought you
hold
asked me
on.
this.
Dr. Theo Champong, I don't know
please,
if you share
we all say that
Dennis's
we are
view,
Supreme Court.
but even if you
Constitutional law,
don't, what do you make of the Supreme Court in at least 3 different decisions, even though those pronouncements are not what we call the star decisis that decides the case? You see that prima facie for a Chief Justice is actually not in the Constitution. It is the Supreme Court that made a decision and said, the same way that if you are removing any judge or a judge of the Superior Court, you get the CJ to make a prima facie. If you want to remove the Chief Justice, you must also do a prima facie. It's not in the Constitution. The Supreme Court said it, and now it has become part of our law. This same Supreme Court, on 3 different occasions, has made pronouncements which we can say are not law. But they say that if a Chief Justice is removed, they are equally removed as a Justice of the Superior Court. Do you think it's as straight as this one?
Yeah, so fundamentally, the point that I have been asking myself, right, is does the Constitution treat the Chief Justice and then the Justice of the Supreme Court as distinct constitutional roles with separate sort of appointment routes? And if that were the case, then in other words, does the removal of a Chief Justice then automatically also remove her as a justice of the Supreme Court? Because that's the core and the argument that Justice Torkonoo really is making. And my view, or sort of what she's arguing, right, is that these are very two distinct roles. And when you look at the constitutional provisions that others have cited, the processes for the removal are slightly different, but the grounds for removal is pretty much the same. So in my view, the starting point is 1461, right? And the 1461, which you read, which I luckily have my old copy here as well, says that a justice of the Superior Court or a chairman of a regional tribunal shall not be removed from office except on those three grounds which you read: stated misbehavior, incompetence, or grounds of inability to perform due to infirmity of body or mind. Then the 1462 all the way to 1466 really gives the process for the removal. So for me, the point that I argue my position on is the first 1461, the beginning point: a justice of the Superior Court. Is the Chief Justice a justice of the Superior Court? Yes. Was she removed on any of these three grounds: stated misbehavior, incompetence, or inability to perform? And we know that per the report that was issued, she has been removed on the grounds of stated misbehavior. And it's quite clear I'm no lawyer, but just reading this and applying sort of logic to all of this, once she has been removed as the Chief Justice, automatically she loses her position as a justice of the Supreme Court on the grounds of the stated behavior or incompetence or any of the other things that have been mentioned. So I don't want to beat about the bush. The starting point, which is very clear to me, is 1461. The 1462 and all the other processes around that to 6 is really in terms of the process by which you go about doing that removal. And if she has been removed on the basis of stated misbehavior, and it says in the 1461, a justice of the Superior Court, then I struggle to see personally, how we could sort of argue that the two are distinct roles. But again, she has the right to go to court. And this going to court or even taking it up in other sort of separate legal processes can only help improve our jurisprudence, right? We are debating this. If she goes and the court rules in a separate way, that becomes a settled law. But as far as I have read this constitution, especially on the 1461 and the grounds for removal, that clearly says that a justice of the Superior Court, and the Chief Justice is a justice of the Superior Court. In this case here, it's a bit of a, for me, moot point to sort of argue that the two are slightly distinct, and therefore she cannot be removed. Once she's been removed as a justice, as a Chief Justice, then she should still stay as a justice of the Supreme Court. I mean, even put the legalities aside, but in terms of even the optics, right? How do you then still go back to the court, engage with your other colleagues and all of that? It doesn't really kind of come across right.
Thank you very much. Do you still want to say something? Hold on. Please hold on. So as Roxanne referred to the three cases, in 1996, in the Justice Saban case, Justice Pega said that the removal of the Chief Justice as a fallout, a judge of the Supreme Court, the substratum of the plaintiff case was that as we have stated earlier, is that the second defendant is not a man of high moral character and proving integrity to be the Chief Justice. Ipso facto, a judge of the Supreme Court, since the qualifications are admittedly the same, or if the second defendant is disqualified from occupying the post of Chief Justice on grounds of lack of integrity, I do not see how he can continue to be a judge of the Supreme Court. And then in 2006, 2005, Modibo Okran in that other case says, with no such gut feeling, one is left only with Article 146, Clause 1. And since the removal of the Chief Justice of Ghana from office is pegged to the same set of grounds as any other Superior Court judge, the Chief Justice, upon removal, will by implication also lose his position as a judge, unfortunate as it may be.
Yes, Sam, this matter actually came up in the Ajechum case. There was an issue. And the court determined that issue. So here's what Justice Dr. Ban said. Are the administrative acts of the Chief Justice immune from the impeachment process? The next declaration, so I want to read. I won't say anything. I just want to read what he wrote quickly.
Yeah.
The next declaration whose grant or refusal I will consider is the first one sought by the plaintiff. It will be recalled that the declaration sought is in the following terms. A declaration that the petition dated 13th January 2006 presented by Mr. Brian Akwete to the President, which relates to the removal of the Chief Justice, is in respect of the performance of administrative functions of the CJ within the meaning of Article 1254 of the Constitution, and is therefore inconsistent with the said article. Then he went on, but this is where he exploded. He exploded this way. He said, I think that the plaintiffs, or let me give this argument. Further in paragraph 8, he sums out the essence of his argument as follows. The exercise of administrative powers by the Chief Justice, such as the transfer of enforcement of discipline among judges, enjoys complete autonomy and freedom from interference by the executive and parliament. The effect of the President's appointment of Committee 2, in essence, question or inquire into the exercise of those administrative powers by the Chief Justice, is to violate clear constitutional dictates and can properly be regarded as a breach of Article 1271 and 2